He was a gold medalist of DU. He is a member of Bar Council of Delhi Bar Association. Sir is a founding partner in the Litigation, Arbitration and Compliance group of the firm. His area of practice focuses on civil and commercial disputes, labor law, consumer protection, and commercial criminal arbitration. Under his supervision, at present the firm is successfully handling 614 district forums, including Supreme Court and various high courts. Before joining BSK Legal, Sir has worked over 10 years as a senior legal consultant. We welcome our esteemed speaker of today's academic webinar series 3. I also welcome our young students participating in today's webinar. So let's initiate this session with our speaker, Advocate Sanjay Kumar Chadha, Managing Director, BSK Legal. We welcome you, sir. Kindly enlighten our audience with your kind words. Over to you, sir.
Thank you very much, ma'am. And it's an immense pleasure for me to be part of this webinar series, which is being conducted by CPJ. I can see Dr. Amit Jain. He's also there. Thank you very much, Dr. Jain. And the most important thing about Dr. Jain is that he's the one who has connected me with this prestigious institute. And today, I would also like to, I could see many faces which are known to me. Many of your students, I would say more than 100 students have, they were in connection with me. Their faces I could see. Ashish Priya has just opened his, I can name them, 100 of them, with my folded eyes, meaning that they are not only brilliant in their work, but also they have made the relationship with me. That's one of the key factors for this profession, I must say so. For this profession, PR is one of the very important elements. So I am always there for your students, whether they have interned with me. I can see many of them are there. I can see their faces right away. Ash Verma, I can see you, and many of them. So I'm not now going, this is the last name I took. So thank you very much, Dr. Amit Jain, for connecting with me, these students. And with them, I spent time during those internship sessions which I took. So that's part of, that will remain always with me in my memory lane if I go. Now, today's topic is a very important topic and is very, very dear to me. And what I feel is that this is the topic which has immense scope in the time to come. So all the students, all the legal fraternity, which is today part of this event, I just wanted to tell you that it is a very, very important aspect of law. ADR, as ma'am has very rightly said, that this includes various dimensions, various aspects, and how, this gives the result. We know what is the principal goal of our justice delivery system, if I may ask myself. It is to decide a dispute. It is to resolve a dispute. And when we go to the court, I would say, does not resolve the dispute. It decides the case. It disposes of the case. But it doesn't resolve the dispute. On the other hand, if I go to the ADR, alternative dispute redressal, as we call it, in short, ADR, here the disputes are resolved. There are events. I will share with you my own experience. I will be talking about the practical aspect. I will be talking to you what are the dimensions. And to begin with this, I think I should first of all tell all of you that what are the benefits of ADR? What are the benefits of ADR per se? The most important is it is very speedy, very cheaper. Why? How it is cheap, speedy? In courts, we all, you all of must have heard about it, that whenever डॉक्टर और वकील के चंगुल में नहीं फंसना चाहिए, सालों साल लग जाते हैं. दिस इज व्हाट इज द सेइंग. सालों साल लगते हैं केसेस में. देयर इज नो डाउट अबाउट इट. बट विद अडॉप्टिंग alternative dispute redressal mechanism, we can very speedily close the dispute, resolve the dispute. The alternative dispute redressal methods are absolutely informal in nature. It is informal, like whenever, in the court, the procedures, the processes are very, very formal in nature. But here, when we adopt the different models of ADR, they are very, very informal in nature. You can, meet anywhere and get this, decide the dispute, get your dispute resolved. It is very convenient as far as the time is concerned. Courts have fixed time. You can have mediation, arbitration, conciliation even in the evening, 7 o'clock, 8 o'clock, as per your time. There is no prescribed procedure as such. Of course, you cannot do illegal things, but there are prescribed procedures. So procedure is also soft, whatever procedure you want to adopt. Forum, whether you want one judge, two judge, whatever. So all kind of flexibility is also there. Convenient forum, as we call it. Now we can also, judges, a judge cannot be an expert sometime in the subject. But here, if you want to get your dispute redressed by some judge, you want an expert, you can very well have an expert. And that expert can mediate. That expert can arbitrate. Now, what is the method of, I must say, how, technical things? I can give an example. Let's say a bridge was made and some dispute has arisen between the contractor and the government, let's say, for the time being. So if there is an arbitration clause, you can have an arbitrator who is not a judge by qualification, but as an engineer, you can make him. He can very well view what is the deficiencies. So that benefit is here if we talk about the benefits of ADR. So technical disputes, here we can very well use this benefit, which you might not get when you have case in the court of law. And the other very important, as I may say so, the very important benefit is that there is a huge burden on our courts. We all are well aware of it. We have a great big population, high population. If you compare the number of judges vis-a-vis the population, I would say the number is extremely low. Not low, extremely low. So because of that reason, there is a huge pressure on the courts. So this alternative dispute redressal can take away that burden and the courts have less burden. And outside the court, by method of various methods, we will come to that, what all are the methods. then even to the extent that court fees is to be paid when we are there in the courts, you have to pay the court fee. Here you save the court fee also. So there are many benefits. Another very important benefit, if I may remind to myself, is confidentiality. All of you are well aware that nobody wants to disclose the important confidential information of his or her to anybody. So how the confidentiality can be maintained here? I'll tell you how. One more aspect which is very important is whenever a case is filed in the court of law, after the case is decided, the document or the case papers become public property. You must be aware of it. So once it is a public property, you can go and check those documents. Anybody can go and check by paying a very meager amount of court fees, inspection charges as we call it. Very small amount. So the confidentiality goes. So what has happened internationally, if I may ask, and may I put before all of you, internationally, if I may say, big corporates, they don't want to fight the cases. Big people who have confidential information, if the agreement is disclosed before the people, the others, their competitors will come to know about it. So they also want this confidentiality to be kept. And that is what, if we talk about ADR, we can very well keep that information with us. The information will remain with you. I've got an experience myself. I've done many mediations and over 200 arbitrations I have done, where I was the arbitrator also in above 200 cases I did. There was a time when I was acting as an arbitrator. So I've seen all these benefits certainly were there. Very quick, speedy disposal. We have disposed of cases in days, months is far. So that is what are the very, very beneficial things which are there if we talk about the benefits of ADR. One more, I just remember I was reading an article by some US author. He has said that this ADR, it opens various doors for the people whose disputes are there. So, many door resolutions, they call it. Or rather, one more word they had used for ADR is, it is there, the full form is alternative dispute redressal. But what they say is that it is appropriate dispute redressal. I don't remember who has said so, but appropriate dispute redressal. That means that is the most appropriate way of resolving the dispute. So these are the fundamentally, if I tell all of you, the benefits of ADR. Now, what is ADR? As I just mentioned, appropriate dispute redressal is another word coined by some American author. I don't remember the name right now. I've read it somewhere. Just came into my mind. So ADR consists of, if I may say, arbitration, negotiations, conciliation, mediation, ombudsman, and as far as Indian context is concerned, Lok Adalat, then Lokpal, all that is very much, these are the types of alternative dispute redressal. So let us take them one by one. Primarily, my concentration for today's discussion would be on arbitration. And of course, I will touch base the most favorite of mine, that is mediation. So these two I will talk about. Let us begin with an arbitration, how the law of arbitration has developed in India, what is the potential, what is the future. If I may use the word of our own uh, Supreme Court Justice Fali Nariman, he says that the future is ADR. Future is alternative dispute redressal only. So, as I'm speaking with a lot of budding lawyers today, I must say, yes, it is the future, and all of you must, think about it, making a specific career in ADR only. And there are people who are really doing a lot of efforts in this field. I remember Arbitration Act. We already had an Arbitration Act, 1940 Act. It was there. You know, uh, initially when I started, it was this act only which was there. On 16th of August 1996, one act called Arbitration and Conciliation Act 1996 was passed. We were having another set of Arbitration Act 1940, which was existing, but this new law was passed. I'll tell you the background why the new act was needed, why it was basically this new Act 1996 Act was passed. It was to consolidate and amend the law relating to domestic as well as the international arbitration, international commercial arbitration, be more specific, if I may say so. Now, earlier law was very, very fit as far as the domestic arbitration was concerned, but new act was needed. Now, there is another story behind it. There is not story, there is another very important element which is necessary. As all of us are well aware of this, that during 1980s, 90s, there was a big globalization was going on. Even in our country, 1991 is the year when, under the supreme leadership of uh, Sri Manmohan Singh ji, we started the as we call it, the privatization, globalization, and all these new dimensions which you are seeing, that has started. The prime minister of the country was at that point of time, was Sri Narasimha Rao ji. So that was the beginning of the era of globalization, privatization in our country. Now, moving, just touching base, I just wanted to tell you, prior to that, because of the internationalization, becoming of a global village, if I may say so, it was a making of a global village as far as the this thing is concerned. Now, what had happened in the year 1985, United Nations General Assembly, UNGA, has passed a model rules of international commercial arbitration in the year 1985. It's very important. Now, why they have passed it? They have passed these laws with one orientation. The orientation was that as we all are heading, all the countries are heading towards the globalization, and lot of international trade was expanding like anything. So there was, to resolve these disputes, there should be a uniformity among the arbitration laws of various countries. Let's say, for example, Iran wanted to invest some money in India. Iran has a different law, India has a different law. If we talk about even the arbitration law, that is also different at that point of time. So that is the reason, this was just an hypothetical example I gave. So that is the reason, for uniform legal framework, this law was made, and a comprehensive guidelines, if I may say so, were mentioned in this model law of commercial arbitration. Comprehensive guidelines were given to whosoever was adopting. We were one of the participants of this event, which took place in 1985, as I said. And that is what we also adopted. That is what we also incorporated in our law. So that is the background in which this law came into existence. Now, you know, I would also say that even the preface of the law, if you read, you go through, you will find that it says that it is a comprehensive law. But I have a different opinion. It is still a developing law. It is not a comprehensive law. If you speak to me, if my opinion is concerned, it is not a comprehensive law, though it covers every aspect, but it is a developing law. We have in last 24 years there are a lot of developments which have taken place. In last 24 years of life of this law, lot of changes have also taken place. I will come to that as well, prior to which I would just touch base few sections, few important provisions of Arbitration Act which my listeners should know. First is, what is arbitration defined? Section 21A, as the definition clauses there in this act. So you must go through at least 4 or 5 clauses are must for each of you. Section uh, Section 21A. So what I could read Dr. Amit Jain's message. Yes. So what I will do is I will divide my this discussion which I am taking with discussing with all of you is in 2 parts. First, I will explain you whatever is there in my mind, and then we will take up the questions and answer. Then we will have a Q&A session. I think that will be fine. So if and you have any questions, you please write in the chat box, and I think somebody will put those questions to me, and I will certainly love to reply those questions. So to me, I would like to just touch base few. First, section 2, you all must read. It defines what is arbitration, what is arbitration award, what is arbitration agreement, what is arbitration award, tribunal, 2 judges, one. All that is defined, so must see that. Other than that, I would just talk about 2 or 3 important provisions of this act, and then I will come to how the law has developed so far. Section, it is very important. Section 9. It is Section 9 is about the interim measures by the court. In case there is some interim order is to be passed, the court can pass even ex parte orders in cases of arbitration. So Section 9 is one of the most widely used sections is Section 9. Similarly, Section 11 is what is another section which is being used very widely as far as the arbitration is concerned. So you must know appointment of arbitrator. So appointment of arbitrator is Section 11, where when both the parties are not able to appoint an arbitrator, or they have agreed that they will go to the court and see that who will be appointed as an arbitrator, then they can very well approach the competent court for appointment of the arbitrator. Now, there is a chapter 5 in the 1996 Act which provides the conduct of arbitration proceedings, how it has to, what is the place of arbitration, procedure of the arbitration, language of the arbitration, etc. All those things are very specifically mentioned in this particular section, in this chapter, if I may say so. Now, I said that this is one of the very, very important aspect of alternative dispute redressal system, as Sunita ji has very rightly defined that this is one consists of so many other aspects. Now, I would like to tell you, as we are discussing about arbitration law has developed multifold. It has developed in last 24 years. It has developed a lot, and sometime as you can say that it has gone little ahead, and sometime it has with the course of time, sometime it has not progressed that much which it should have progressed. The judgments like Renu Sagar judgment 1994 onwards, that's the previous act, though Bantia judgment, and many more judgments have given shape to this law. Slowly and gradually, this law has developed. I want to tell you, this law has corrected, if I may use the right word, has not only corrected itself, improved upon itself by both means, judicial pronouncements and legislative uh, law making, also amendments as we call it. I will just touch base those two aspects. Various judicial pronouncements. It reminds me of one of my case when I was arguing a case before. That's what is the legal as when you are practicing, you come to know and you see that. I remember once there was, during 2007 or 8, I think I'm talking about, there was a case I was fighting at Agra. It was a big claim against one of the multinational firm. So there were 10 claims in total, out of which 9, the judge at the district judge at Agra said that it is a claim which is 9 out of 10 claims are arbitrable, and one claim is non-arbitrable. So we really objected to it. So that kind of hurdles were there. Then we took this case to Allahabad High Court, where we got a favorable order that uh, it has to be seen in totality and all that. Why I gave this example is very important. That we appeared before Justice Agrawal, I remember. So and where when I mentioned this matter, he said, "Oh, but I don't know the arbitration law." So I thought the first question came into my mind was whether this judge is going to transfer this case. The answer, immediately I thought that it will be the next thing. But the honorable judge, what he did, he said, Mr. Chadha, we will adjourn this matter for a week, and then on next week, on so and so date, I will hear the matter. And that's what is the beauty, I'm just saying. Why I'm saying so? Because that is what the judge, that is what is that a new dimension. The judge said, I will read. So this also happens sometime. But anyways, that was just a touching thing came into my mind, so I shared it. Coming back to the most important aspect, that this law has seen various corrections, various changes, positive corrections, I must say, both judiciary as well as through legislature. The massive correction, if I may use the word massive, why I'm saying massive, because it is the one of the major changes which took place was when in the year 2015, very recently, 5 years back, major amendments were done based upon the recommendation of one of my favorite judges, Justice J. Ajit Shah, who was at that point of time chairman of the Law Commission, and he recommended various recommendations were there for as I may say, for the improvement of law, the arbitration, and many of them were taken, adopted by the government, and a major change took place in the year 2015. I'm not going to touch about it, but I'm just saying that law is developing. Law is developing. Immediately after this, a very high-powered committee was made by the government, central government, under the able leadership of dynamic judge Justice Sri Krishna, as we call it, Sri Krishna Commission, and Justice Sri Krishna, again, lover of ADR, if I may say so, and one of the another set of brilliant judges we have, Justice Sri Krishna, decided and give a lot of inputs and detailed analysis what's done, and based upon his recommendation, I remember in the year 2019, very recently, a major amendment was made, I would like to touch base a few aspects which were very major amendments which took place. And then I will also tell, because we are talking about what are the challenges. So in challenges, there are certain recommendations, certain aspects which were touched by Justice Shri Krishna and Justice Shah, both, but they were not precisely. So far, we are still waiting, but you will see the dynamic changes which have taken place. See, as all these people, even the government, they are well aware of the fact that this particular law is going to develop. It is on the growth path. It is growing day to day. So that is how the most important amendment which took place and which has added, I think, part 1A to the part 1A was added, and whereby Arbitration Council of India is framed, though it has not came into existence so far, and because of this corona and all, I feel it will come, but the law is there now, Arbitration Council, to regulate the arbitration law practice in India. So we have now a Arbitration Council of India. We already have it. This body consists of a judge of Supreme Court or the CJI, retired. Arbitration practitioner can be part of it. Then academicians can be there, and recognized person from commercial bodies, CII, etc., etc. So these are the four people. I would say these are the four stakeholders, if I'm not wrong. But in this, two more persons are also added. Two secretary level bureaucrats are also added by the law. I don't know what was the relevance of them, but that is part of it. I'm just mentioning it. So that is a very, very important aspect. What is the objective of this council? It will act for the growth, for the betterment, for the all the positive aspects of arbitration. It will act. Another very important thing which was added by 2019 amendment, all of you must know this, that 8th schedule is added, which set out the qualification of the arbitrator. I will come to that because there is a ground where it has been criticized also. But anyways, a 8th schedule is added for our knowledge. Now, a precise qualification is mentioned for all the, as we call, the arbitrators, which was missing earlier. Then one more thing is done, that time-bound framework is now increased. Now another 6 months are also given for completing the pleadings, which is there. And finally, what I feel, there are so many changes have taken place, but I'll touch base few 4 or 5 points. Finally, as far as the arbitration is concerned, I will touch base few points which I feel should have been there, though they are recommended by judges. If I'm not, like the most important is Justice Shri Krishna. Justice Shri Krishna has directly approved these things, but those recommendations are somehow overlooked by the government. Primarily, I think we all were expecting that model rules of procedure for domestic arbitration should have been there. What are the rules? Because as per the law, if we talk, the law says that the procedure, what procedure is to be adopted, has to be decided by the arbitrator. So what was expected now was that there should be a arbitral procedure as model rules of procedure, if I may say so, can be taken. Now, second is that uh, which is which is very very sought for and very very uh, desired thing if we have to develop the arbitration law. I'll just touch base that also, that there was a demand of amendment in the arbitration in the advocates act. Now please listen to this very carefully, which is not accepted. Why? Because there are lot of lawyers who are against it. Now what is the amendment which was recommended by Justice Sri Krishna? That was that international lawyers should be permitted for arbitration. So this was one thing which was asked, desired. The objective was that we want that India should develop as an hub, arbitration hub for the international um, arbitrations. We want that international arbitration should happen here. Delhi, Bombay, Calcutta, Chennai, they should have international arbitrations. But on the other hand, we are not accepting the international lawyers. So that is what the reason, as I said, that there has been a great opposition from various lawyers. But on the other hand, everybody wants that India should develop as an arbitration hub. Singapore is an arbitration hub. Singapore arbitration, all of you are well aware of it. Similarly, London, you have got great arbitration, international arbitration. The seat has become London, Singapore. Why not India? We have got such a brilliant brains here. But we are on this path. I feel that that day is not far. All these things will be taken care. And India will also become a hub for international arbitration. As we have seen that what positivity is there in these alternative dispute redressal. Now, two more things I will talk about this arbitration, and then we will proceed to mediation, which is another very important aspect of this alternative dispute redressal. One aspect is that, as I said, in 8th schedule, we have talked about the qualification of the judges, arbitrators, sorry. So, on the other hand, this qualification restricts that only those people can be made arbitrators who are citizens of India. Then again, it is in contradiction with our aim that we should have a internationally known arbitration in our country. So as far as if we talk about the international arbitration, then we will have to somehow allow the entry of the international lawyers, international arbitrators, experts, if I may say so. So that's primarily on what ground the arbitration is being criticized. This new amendment is being criticized primarily. But I must say so that if you go to the court today means these days, or during this, not a lot of arbitration is now on. Even in Delhi High Court, we have seen that Delhi International Arbitration Center is there at the back of the High Court. Lot arbitration is going on. So to me, and I know it very well, that all of you have great scope in arbitration. So please keep this in your mind. Whenever this is there in your curriculum, you must speak with your teacher, because they are the best mentor, they are the best guide for any student. I'm telling you, trust me, whatever they will tell you, nobody else can guide you. So this is what is about arbitration. Now I would like to, and if you want, I can give you a few examples of where we have seen still some lacunas are there. There are I just remember one case. I'm just telling you, September 2019, we got an order from Honorable High Court of Delhi for appointment of arbitrator in a case where there was a claim of about 3.5 crores. this claim of a private individual who had worked for the government. So the arbitration fees is to be deposited in advance. We deposited our share of the fees. 50% share is to be paid by us, 50% is to be paid by the government. But look at this, 1 year has passed. The government has not deposited its fees. So the entire objective of arbitration is ruined, I would say. 1.5 years has gone on the count that the government is not paying the arbitrator's fee. The arbitration has not started. So these loopholes are to be filled. We have to see how we have to fill them. But certainly it is a new dimension. It is something which has, I would say, changed the litigation world. So that is one thing. Now I would like to talk about negotiation. Negotiation is where there is a dispute between the two parties. They want to close the dispute amicably. First they talk about it and they resolve the dispute. This method is called negotiations. A one-way extension of negotiation is mediation, where an independent neutral person, where this neutral independent person, and I call him a mediation expert. They are trained mediators also, we have seen. So they assist the parties. Please mind these words. They assist the parties to amicably resolve their dispute. This is what is the beauty. Meaning thereby, if there is a dispute between the two people, they can go to the mediator. Mediator can ask them, look, this is your proposition, this is this proposition, this has this. बैठ के amicably चीज को समाप्त कर देना, डिस्प्यूट को रिजॉल्व कर देना. ये एक बहुत बहुत उपलब्धिपूर्ण चीज है मेरा मानना है. और बहुत बेहतरीन तरीके से हमने देखा कि आर्बिट्रेशन मीडिएशन की वजह से लाखों की संख्या में डिस्प्यूट्स रिजॉल्व हो रहे हैं. The beauty of mediation is that no one wins, no one loses the case. The case is resolved. जब हम मीडिएशन के लिए जाते हैं तो मीडिएटर के कमरे में मैंने देखा है हर जगह पे एक बोर्ड लगा होता है that here no one wins, no one loses. Everybody, when you enter the room, you have some problem. When you go out of the room, the dispute is resolved. And by mediation, if the dispute is resolved, it is resolved for all, resolved fully, because both the parties agree to it. There is no pressure of law. As a matter of fact, the mediation does not have the force of, you cannot go and go and file an execution decree for mediation. It is a kind of compromise with the help of, with the assistance of the trained mediators these days. It is, as I begin, it is a next stage of negotiation, if may I say. And look, I just, a day before I was talking to a group of students where I had mentioned this, and I would mention this case here today also. It will show the beauty of the mediation. Now, there were, when I started my practice way back in the year 1995, after 10 years of the practice, 2006 or 7 something, somewhere, I received a case. Now, this case was going on between the two brothers since 1973. Quite a well-off families of South Delhi. They were having various properties, various businesses, but both businesses as well as properties were Dada has given in the name of the two brothers. Half properties in this brother, half properties in other brother's name. Everything was mixed. common. They were having litigation since 1973. In the year 2008, if I'm not wrong, I received a call that from the client that we want to hire your services. I have left my earlier lawyer. I said, okay, you send the file, I will read it, and then we'll meet up. I was in the court at that point of time, High Court, and I received a call that files have come, sir. So where we have to put the files? I said, keep them in my room. I will, what is there to ask on it? Then बात खत्म हो गई. मैं lunch के लिए अपने office आया. I was surprised to reach my room. I said, what is this? They said, these are the files of Mr. So and so. I said, what is this? There were about 800 files. And they said that approximately 44 matters are going on between the brothers, family of brother, even the elder brother died also. I said, okay. I said, please remove these files so that I sit in my room. And those files were removed. Next day, there was a case. I had gone there in the court. I mentioned before the court, I said, it is a dispute between the two brothers. One brother has expired. Now the dispute is between one Chacha and Bhatijas. This dispute is going on. So such dispute I think it is a dispute between the family. It should be referred to the mediation. Immediately, the other side said that we are not at all inclined to go for mediation. It is going on, it is a stage of argument. I said, then if you want the argument to happen, I need at least 4 weeks, that is 1 month time to prepare, because it's a very big, huge case wherein a lot of aspects are there. I need that kind of understanding. And my proposal is, I said, my proposal is that as there is a time of 1 month, why can't during this month, after a month we are meeting for the arguments, why can't during this month we refer this matter for mediation? I would try and convince these people to get the dispute closed as fast as possible. Now, the judge agreed to it. District judge said, yes, you can refer the matter. We can refer the matter for arbitration. If it is not, refer the matter for mediation. If it is not, you can come back and the proceedings will go on. That's what happened. I just wanted to communicate to you without elaborating much on it, though the parties, the person who expired, his 3 sons, the one was in Bombay, one was in Udaipur, and one was in Delhi. One daughter was somewhere in Calcutta, and I said, please call everybody. Initially, there was a hitch that nothing will happen. Then what I wanted to tell you, when I started discussing with them, I only gave one reasoning, which struck to all of them. I said, this case is going on since how many years? All of them immediately replied, somewhere around 35 years or so. I said, your father has gone during the mid of this particular cases. I can assure you, even you all will not be able to see the judgments, because some matter will be decided, the other party will go to the High Court. If High Court decides, they will go to the Supreme Court. This chain will not stop. There are so many litigations between you, and your next generation will also not get the fruits of this money, properties, etc., which are yours, but you are unable to enjoy the benefits of it because of one reason or the other. If you go and sell that property today, the buyer will say that it is a litigating property. They will not give you that much money. This thing struck to them, and you will be surprised by sitting there with them. By one order, we got all 43 cases decided. Just 2-3 days, 5 days, and lot of efforts. This is the beauty of mediation. Can anybody think that by any stroke of imagination, 45 cases deciding in one day by one order? But it happened. This is my own experience I'm sharing with you. So this is what is the beauty, as rightly stated by somebody, that mediation, no one wins, no one loses. And this particular point I wanted to share with you, this why this is so much now, it is becoming popular. I would say day by day, it is now a most sought for field. Our own courts, be it Supreme Court, High Court, District Court, every courts have mediation centers now. Moving ahead, just another thought came into my mind. Even the government and all the people who are there, who I would say decision makers, who make the laws for serving the society, I feel they have also realized that mediation is such a dynamic concept, and they themselves have, very recent Consumer Protection Act 2019, 9th August 2019, the consumer law was passed, which came into existence and came into power during this corona period. 20th July 2020, the rules were activated, rules were made, and earlier law of 1986 was repealed. 20th July 2020 onwards, Consumer Protection Act was passed. And the most beautiful part of it is part 5. In the part 5, mediation is added. So now if there is a dispute of a consumer, many changes were made, but this mediation is added there as a compulsory part in the law book, which was not there earlier. Now, if a case is filed, if there is a complaint by a consumer against somebody, let's say business person or a service provider, first that case is to go through the process of mediation. A trained mediator will sit, will talk to both the parties, will try and tell them that, look, this is your merit, this is the deficiency, why can't we resolve it, where is the need to resolve it. And I, as I've said earlier also, that I feel that this is something very, very dynamic. Half of the consumer cases will be over if we do this mediation practice in a sincere manner. So that is what is the beauty of mediation. Similarly, Lok Adalat, Ombudsman, I would just give 2 minutes to Lok Adalat and 2 minutes to Ombudsman, and then we will open the floor for all of you to put questions to me. If you want to ask something, I will be very happy to answer those questions. First is, I would talk about Ombudsman. This is another way of alternative dispute redressal. We have, all of you are aware that banks have banking ombudsman. Insurance companies have insurance ombudsman. If you have some grievance, you go there, give your application, and a quasi-judicial body of ombudsman will pass an order which is binding upon the parties. So ombudsman is, and disputes have been resolved before, otherwise they would have gone to the court, pay the court fee, lawyer, X, Y, Z, all that thing is curtailed. So ombudsman is another medium through which we have seen a lot of disputes getting resolved. And even these insurance companies, they prefer, because they also save, they also cut on the legal cost. So that is another very important aspect. Similarly, a new dimension, Justice P. N. Bhagwati, I remember, was one of the instrumental in pronouncing it, that is called Lok Adalat. We have seen now, you know, a new dimension has started with Lok Adalats, where small crime, if it is a criminal law related, or petty offenses, if the criminal things, they are resolved with some fine. Traffic challans, thousands of traffic challans are resolved in one Lok Adalat. Compromise takes place in Lok Adalat. So Lok Adalat is another very important facet of ADR, important aspect of alternative dispute redressal. I feel this is what is the new dimension of ADR. I feel that future of this country, future internationally also, ADR is very popular in America also, in Europe also. British system has also adopted ADR. So ADR is one of the most important and dynamic field where we can very well see that it will end up finishing lot of disputes as the benefit I had conveyed to all of you in the beginning. So ADR is it has a future. So all the law students who are here today, I would request you take this in a very very serious manner, and it has a great future ahead. One last thing I wanted to say, even in Delhi we have seen in Greater Kailash one private sector have started this arbitration centers. So it's on the growth path. Please believe it. And we see every day some or the other new development in the field of ADR is happening. All the judges are very much convinced of the constitutional courts that ADRs are the only alternative for the speedy justice, for the cheaper justice, for the informal way of closing the matters is only ADR. So all of you are required to know much more about ADR. Please try and read about it. Please try and discuss with your teachers, with your other lawyers wherever you work, and participate also in ADRs. That's what I feel. And here I would like to now sum up. And now, if you have any questions, in a very small manner, I have tried and told you what is try and convey to you that what are the systems, what is ADR and how it is important in today's era. Thank you very much.
Thank you so much, sir, for rightly explaining and making the students understand the different procedure for settling disputes without litigation, such as through arbitration, mediation, or negotiation. So students, moving ahead, now the forum is open for question and answer round. If any student has any question, he or she can write his or her questions on the chat box along with the names, and the same would be answered here itself. So there is one question, sir.
Yes,
Can
yes,
we,
yes.
yeah, sir, can you hear me?
Yes, yes, yes. I'm sorry.
Yeah, sir, there is a question from Ashish Priya. Can mediation and arbitration be combined?
Yes, this what happens is sometime, as I said, that mediation's judgment is not judgment. Mediation, whatever is the outcome of mediation, you cannot get this executed. So the best way of execution is you get your mediation order or agreement, as we call it, the terms and condition of mediation where both the parties have agreed. What we should do, as Ashish has rightly said, that we can combine both. What we can do is we can take this uh, whatever is agreed, the agreement, as I'm broadly saying, the terms and condition which are agreed, to an arbitrator and ask the arbitrator to pass an arbitration award in terms of this, then it becomes a binding, then it gets a binding force of law. That is the very right way of moving. If in the settlement it is agreed that after 5 years you will do this, then after 5 years that person doesn't do, you have to go through the entire process once again. To make it fully secure and sound, you should get it, in the shape of arbitration award. Very right question, and I appreciate it.
Thank you, sir. There is one more question. If a case does not settle at first mediation session, so what is the next step or what is the next procedure which we follow?
All right. If a case is referred by the court for mediation, then always a date is given that during this time, if the mediation doesn't succeed, the case will go back to the court, and then the normal proceedings will start. But the spirit of question is little different, so I will answer in a little different manner also. That one, let's say if the matter is not settled in one sitting, I myself have seen the example which I gave. We had about 7 to 8 sittings. In those 8 sittings, we compromised. We came to a conclusion. Understood? So if it is possible by one way or the other, that is the reason the mediation, the role of trained mediator, these days a lot of lawyers are getting training for mediation. Special methodology is taught to them. Special way of handling the mediation is given to them. So, and that is how they handle this, all these cases. And the outcome, if you ask me, one very positive input I wanted to give to all of you. When there is a mediation, we have seen over 60% of cases are resolved. Only one thing is needed. The mediator asks you only one thing. Do you have the intention to close these matters, or you want to come to the court in this manner day and night, spend money on various aspects like court fees, paying to the lawyer, your own time's cost, mental stress, everything will go. Come up with an open mind. That's what a mediator asks before starting the mediation. And we have seen people are now realizing the need of this mediation. One more thing, we have seen the family dispute. Dr. Amit, I want to tell you this. Family dispute, the husband-wife dispute, property distribution. After all, if a dispute is between two brothers, we have seen years takes in the court. But in mediation, the same harmony comes back in the family. This is what is needed. I have seen, Sunita ji, that husband and wife fighting, they were having only very small issue or a very small count. When they sit in the mediation, he said, ABC is not, she is not doing ABC. She said, I am always willing to do this ABC, whatever, it might be anything. And the dispute goes. So why not try this? And that is what Chapter 5 of Consumer Protection Act. Prior to a case, go for mediation. And one more thing just came to my mind. Now, another very new aspect has come. Commercial litigation. Any commercial litigation, before filing in the commercial court, has to go to procedure of mediation first. And what is the fees fixed? If I may tell you, the fees is very meager, just I think 1,000 rupees, if I'm not wrong. That fees is to be paid, and a mediation process will first be done. And if in the mediation, two commercial parties, they settle their dispute. Everything is gone in one week, in 1,000 rupees. Just see the beauty. Beneficial for all the parties. And we have seen getting disputes resolved in such a quick and cheap manner. So mediation, no doubt, is full of positivity only.
Thank you, sir. There is one more question. Are the institutions which are providing ADR is registered or they can operate freely?
Now, so far as our, like, while discussing the arbitration, as I said, Arbitration Council of India has been made. So still little loose elements are there. It's not that tied up as the law, the court procedures, etc. are there. Certainly, that is the reason it is an alternative dispute. That is the reason it is a flexible, the nature is flexible. But certainly, as far as the mediation is concerned, if even if you just think of one thing, if a mediation is being conducted, if a mediation is being done, whether the mediation is done by some individual, whether the mediation is done by the court assistant with the court's assistance, if we are ultimately resolving the dispute, where does this make any difference? So what I feel is that certainly it is a dynamic aspect, and so a lot of work is going on. It is on the path of progress. I would say, the law is correcting, as I said earlier also, law is correcting not only by legislature but also by the judiciary. Judiciary is pronouncing orders. Judiciary is giving protection. Arbitration is given a lot of strength. Mediation, the court is referring the matters to mediation. It is a very active field, and that's what I feel.
Thank you, sir. Last question. This is also asked by Ashish Priya, and the question is a bit. I also wanted to ask this question rather. What is the impact on lawyer income due to ADR process?
Well, I would say, as far as the lawyers are concerned, lawyers, I remember I was with a very famous author of this country. He is no more now, Shri Khushwant Singh ji. I was sitting with him. So while he was also a lawyer, all of you must know this. We did a television show together. It's long back. And after the show, I was talking to him. He said, "What?" I said, "Why you have not practiced?" He said, "What is there? You are earning out of the fight of two people." Law, as per him, lawyers are earning out of the fight of two people. You just see, realize it. So it is not always the case. First, I wanted to tell you this is a very, very pious profession. I feel very proud today that I am in this stream. I have got the capacity to help thousands, and which I am doing. I feel so. And I feel very proud about it, that at least I am able to help few people. As far as the earning on the count of the ADR reduced earning is concerned, I would be, not, surprised. I mean, you guys will not be surprised to know this, that arbitration has now become one of the most important source of revenue for lawyers. Big arbitration claims, lawyers are charging hefty fees for that. That's something very different, I would say. But yes, mediation, once as a lawyer, earning really matters, but also one, you know, you just think of it. I'm just putting 40 years of dispute, 44 cases. What these clients must be thinking about? What must have been their perspective about the justice delivery system? they must be really very, very annoyed from it. Now, by adopting this method, by way of mediation, the lawyer has changed their entire, not only perception, but their entire life. All the family has come together, firstly, one. Secondly, they have financially also got a lot of benefits out of it. So, first, that there is no effect of these earning. Lawyers have no, it is not the case that lawyers have no work. If you are a lawyer, make it a point. I'm just write it somewhere and disprove. And you, if you could disprove me, I can bet upon you. You cannot. If you have a law degree, you cannot, भूखे नहीं मर सकते. बहुत काम है. काम की कोई कमी नहीं है हमारे देश में. So don't worry about it. That's what I can say.
Thank you so much, sir, for addressing
I
the
think there
query.
was one person called Sahil Giri. He was raising hand. I am unable to see him now. If he has a question, he can ask me.
Yeah, sir, he's not. Yes, Sahil.
I think he is left.
He's left.
No, he is there, but he is. Yeah, he is there. You wanted to ask some question? Unmute yourself first.
Morning, sir.
हाँ, बताइए कैसे हैं आप?
Yeah. Sir, actually, I just want to know, like in foreign countries, there are many legal forms are there. And in those legal forms, the settlement are done and they just approach to the court for the signature of the judge that we have done the settlement and you just give the attestation of yourself that
that is also available here. You can get your even registered your, as I just gave the example of arbitration. Via mediation, we resolve our dispute and we go to the arbitrator to pass an arbitration award. That is one. Another example, like rent agreement. You can get what you call decree for eviction decree today, that by a mutual agreement that after 3 years he will evict the house. So the agreement can get a shape of the judgment from the court also. Similarly, these agreements can be very well, we can take those agreements to the court and get those registered. Some registrar's office, you can get your agreements registered. So methodologies are changed depending upon what is your agreement. You can get your agreement registered, give them a shape of arbitration award, give them the judicial shape in any ways.
Thank you so much, sir, for addressing the queries of our students. I think there is no more queries from the student side. So now I request our Deputy Director SOL, Dr. Amit Kumar Jain, sir, to give vote of thanks and conclude the session.
Thank you so much, Sunita ji. Being given a vote of thanks is my privilege here. I'm extremely very, very thankful to the Speaker of the Day, Mr. Sanjay Kumar Chadha, Managing Director BSK Legal, for giving his valuable time and support to the students, for providing the insightful knowledge about the ADR, alternate dispute resolution, or I can say that he has given a new word, that appropriate dispute resolution for this ADR. So thankful to him for giving his valuable time and his contribution towards the knowledgeable insight to the students about this particular topic through this webinar today. And I'm also thankful to the teachers, the staff members, those who have planned this webinar, those who have planned this session in this way, so that it is beneficial for the students to learn something from the very knowledgeable person, resource person from the industry, from the law firm. So I'm extremely very thankful for all of them, and as well as for the students also, those who have the good patience. And I've seen that in the due past 1 hour, they have been patiently listening about the topic, about the theme, about the today's webinar. So extremely thankful for that also. Last but not least, I am thankful to the management, thankful to DG sir, who had given us this support to organize such webinars for the knowledge of the students, for gaining the knowledge to the students through this type of platforms. Thank you so much.
Thank you very much. And I would just like to once again say I also would like to give my regards to the DG and all the management of CPJ. And I want to say one thing, that your students are very dear to me. Anybody with the name of CPJ comes to me is welcomed in BSK Legal with open hands, right? So any student needs any help, and I would like to say it to you, Dr. Amit, that you are the one who was instrumental in it. So
Thank
great
you so much,
to
sir.
meet you, and we all are here for the future generation. As ADR is our future, you all are my future. Thank you very much to all of you.
Thank you, sir.
Thank you very much, ma'am. So I would like to leave now. Thank you.
Thank you.